let's take a look at the reality of employment discrimination. Many things have changed for the better since the time when our nation's primary anti-discrimination law, the Civil Rights Act of 1964, was enacted. We have made some progress in combating discrimination in the workplace and making equal employment opportunity a reality, but the job is by no means finished. Rooting out the contemporary manifestations of discrimination may prove even more difficult than confronting the overt exclusion and segregation characteristic of earlier years. Discrimination is inherently difficult to prove. Indeed, much of this course is devoted to explaining the methods that the courts use to decide these complex cases. One indication that discrimination still exists is found in different employment outcomes, such as higher unemployment rates, concentration in lower level jobs, and pay disparities across different races, sexes, and national origin groups. Unequal labor market outcomes need not have discrimination as their cause, but they are consistent with the presence of discrimination. A second type of evidence for the continuing reality of discrimination comes from the large numbers of discrimination cases heard by anti-discrimination or administrative agencies and the courts. The number of discrimination charges filed with the Equal Employment Opportunity Commission varies from year to year, but an average of 93,414 charges were filed each year between 2008 and 2016. Federal court cases alleging discrimination have increased substantially since the early 1990s, often numbering more than 20,000 per year. Not every case presents a valid claim. Indeed, the majority of cases do not conclude with a finding of discrimination. But despite plaintiffs' heavy burden in proving discrimination, courts and agencies decide in thousands of cases each year that discrimination has occurred. Third, studies of employment discrimination show that it's real and pervasive. For example, researchers conducted an experiment to gauge the extent of discrimination against African American job applicants. Responding to newspaper listings for entry-level jobs, the researchers sent resumes that were matched in terms of experience, education, and skills, but differed in terms of the applicant names. Applicants with white-sounding names like Kristen or Lori received 50% more callbacks for interviews than did applicants with black-sounding names like Lakeisha or Tamika, despite equal qualifications as mentioned earlier. When the researchers varied applicant credentials, high-quality candidates with African American sounding names were at least at a greater disadvantage relative to high-quality candidates with white-sounding names. Similar studies found that equally qualified applicants were much less likely to be contacted if they revealed the existence of a disability or were in their mid-60s. Numerous laws aim to advance the goal of equal employment opportunity by prohibiting discrimination. Major federal anti-discrimination statutes include Title VII of the Civil Rights Act of 1964, the Equal Pay Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. The U.S. Constitution, particularly the 14th Amendment's promise of equal protection under the law, also can be used to combat employment discrimination. Executive Order 11246 makes non-discrimination a requirement for contractors and subcontractors doing work for the federal government. States and cities have their own anti-discrimination laws that mirror and sometimes extend federal protections. Clearly, laws prohibiting discrimination account for a large and absolutely central part of employment law. Employment discrimination can be defined as the limitation or denial of employment opportunity based on a person's protected class characteristics. The element of limitation or denial of employment opportunity indicates that it's not prejudice alone that subjects employers to liability, but rather the effects of bias on employment decisions. However, in one variety of a discrimination case, retaliation, the acts that subject an employer to liability are not limited to those that directly affect employment. The concept of an adverse employment action is elastic enough to encompass harassment that does not directly alter a person's employment status, but makes it more difficult to perform well and stay on the job. But minor differences in treatment, like stray, insensitive comments, would not have sufficient impact on employment opportunities to be grounds for discrimination claims. Embedded in this definition of discrimination is the idea that it is a relative concept. An employer that treats all of its employees equally badly has not discriminated. In contrast to other laws that establish specific minimum standards that employers must meet, U.S. anti discrimination laws require consistent, even handed treatment of employees. But equal and unfair treatment of individuals is still not sufficient to establish the existence of discrimination. To have discrimination, the unfair treatment must be based on the person's protected class characteristics. Society deems certain characteristics of people, such as their race, sex, and age, impermissible grounds for making employment decisions. Not all distinctions between people, and not even all those things that have no bearing on a person's ability to do a job, are protected class characteristics. To be sure, protected class characteristics are things that we generally regard as having little or no relationship to the ability to do a job. However, protected class characteristics also are fundamentally objectionable as grounds for making employment decisions. One reason is that most protected class characteristics are either unchangeable or not readily altered. The following is a list of protected classes under federal anti-discrimination statutes. Race and color under Title VII of the Civil Rights Act, sex under Title VII and the Equal Pay Act, national origin under Title VII and the Immigration Reform and Control Act, and religion under Title VII of the Civil Rights Act. The list continues with citizenship under the Immigration Reform and Control Act, age 40 and older under the Age Discrimination in Employment Act, and disability under the Americans with Disabilities Act. Further, pregnancy under the Pregnancy Discrimination Act, military service under the Uniformed Services Employment and Reemployment Rights Act, and genetic information under the Genetic Information Non-Discrimination Act. Other protected classes are recognized under the laws of some states and cities, but not under federal law. Notice that some anti-discrimination statutes limit the definition of protected class to a particular group that is most likely to be the object of discrimination. Discrimination can be further distinguished into 4 types or legal theories: disparate treatment, disparate impact, failure to reasonably accommodate, and retaliation. Disparate treatment is unequal treatment based on one or more protected class characteristics that results in the limitation or denial of employment opportunity. The key element of disparate treatment is discriminatory intent. The meaning of intent in this context is that the decision maker based the decision in whole or in part on a protected class characteristic of the affected employee. It is not necessary that the decision maker understood her actions to be unlawful or desired to harm anyone. Suppose an employer believes that tall people make better managers. In this case, many more women than men would likely lose the opportunity to be managers because considerably more men are at least 6 feet tall. If the employer is really selecting managers based on height and not rejecting qualified women who are more than 6 feet tall, it cannot be said that there is disparate treatment. Yet, it is still troubling that women are being disproportionately excluded from these management jobs on a dubious basis. In fact, this height requirement would most likely be discriminatory because it creates disparate impact. Disparate impact, also known as adverse impact, is the disproportionate limitation or denial of opportunity for some protected class group that results from the use of a neutral practice that cannot be adequately justified. The focus is on discriminatory effects rather than discriminatory intent. In our example, the neutral height requirement does not exclude all women, but it can be expected to exclude substantially more women than men. The employer believes that height is related to managerial ability, but unless the employer is able to present substantial evidence that this connection exists, the employer is guilty of discrimination. Anti-discrimination laws call for reasonable accommodation of employees for qualified disabled persons who need such accommodations and for employees whose religious beliefs come into conflict with their employer's requirements. An employer discriminates through failure to reasonably accommodate by not removing obstacles to employment when doing so would not impose undue hardship on the employer. Retaliation can be defined as punishing employees for seeking to assert their rights under anti-discrimination laws or assisting others in doing so. In deciding whether discrimination has occurred, we first ask whether an employee has been subject to an adverse employment action and whether any link to the protected class characteristics of an employee exists. If the case appears to rise on an issue of discrimination, the next task is to identify the theory of discrimination that best fits the facts of the case. Distinguishing between types of discrimination is important because each type of case is analyzed and decided in a different manner. The fundamental implication of disparate treatment is that employers must not make employment decisions based on the protected class characteristics of their employees. The general strategy for avoiding disparate impact is for employers to closely scrutinize factors used in making employment decisions for their potential to exclude protected class groups and for evidence of their job relatedness. Although employers need to be consistent, they also need to be flexible in accommodating the particular needs of a disabled employee and employees whose religious practices conflict with workplace requirements. Requests for flexibility cannot be ignored or dismissed simply because the requested measures would be a departure from the norm. As with most laws, there are few exceptions, but these basic guidelines go a long way. Finally, employers need to exercise particular care in taking adverse actions against employees who have filed charges or spoken out about discrimination. Such employees do not become untouchable, but having solid reasons for any adverse actions taken under these circumstances is essential. The heart of a disparate treatment case is an allegation that an employment decision was intentionally discriminatory based on a protected class. However, not all disparate treatment cases are analyzed and decided in the same manner, so it's important to distinguish between the different types. Types of disparate treatment cases include facially discriminatory policies or practices, reverse discrimination, pretext, mixed motives, pattern or practice, and harassment. In cases involving facially discriminatory policies or practices, the employer readily admits to using protected class characteristics as a basis for making an employment decision, but insists that there's a sound business reason for doing so. The only way that an employer can prevail in such cases is by showing that the required protected class characteristic is a bona fide occupational qualification for the job in question. This is known as a BFOQ. In a sense, the term reverse discrimination is a misnomer because protected classes such as race and sex include any race and either sex. A scenario found in many reverse discrimination cases is that an employer with an affirmative action plan hires a woman or a person of color. A white male believes that he should have received the employment opportunity instead and sues. The case hinges on whether the particular use of affirmative action was legally permissible. These cases take a different course than other disparate treatment cases. A more complex and common scenario occurs when an employee is denied an employment opportunity and they believe the decision was influenced by the employer's consideration of a protected class characteristic. Pretext cases are so named because if the employee's allegations are true, the employer's explanation is a cover-up for the true discriminatory motive. Sorting out these conflicting claims is no simple task. Because more than one motive can account for a given decision, it is possible for an employer to base an employment decision on both discriminatory and lawful grounds. In mixed motive cases, where strong evidence exists of both discriminatory and lawful motives affecting an employment decision, the employer is guilty of discrimination. However, the plaintiff's award will be minimized if the employer can prove that the same decision would have been made absent the discriminatory motive. Application of a mixed motives analysis is limited to certain statutes and types of claims. It's not available for age discrimination claims under the ADEA, disability discrimination claims under the ADA, or retaliation claims under Title VII. Instead, in age discrimination cases, for example, plaintiffs must show that age was the cause of the challenged adverse employment actions rather than just a contributing factor. Although many disparate treatment cases involve single plaintiffs, the concept of intentional discrimination is not limited to challenges of individual employment decisions. Employer policies that have the effect of segregating certain types or groups into lower paid and less desirable jobs are often at the center of a pattern or practice claim. In pattern or practice claims, the plaintiffs marshal substantial data showing the systematic effects of an employer's discrimination and evidence of intentional discrimination against individuals in the larger affected group. Harassment is a form of disparate treatment because the victim is subjected to inferior working conditions because of their sex, race, or other protected class characteristic. Pretext cases, in which the employer's motive for making an employment decision is disputed, present a difficult problem. Proof of discriminatory intent is essential, yet although the plaintiff bears the burden of proving that discrimination has occurred, the defendant knows the most about why a particular decision was made. The defendant also has an incentive not to be entirely forthcoming if, in fact, the decision was tainted by consideration of an employee's protected class characteristic. In McDonnell Douglas versus Green, the Supreme Court provided a method for deciding pretext cases. This landmark case arose shortly after the passage of the Civil Rights Act of 1964. The plaintiff, Green, was an African American who had worked for an aerospace company as a mechanic and laboratory technician until he was laid off in a business downturn. When the company advertised openings for mechanics about a year later, Green applied for a position. McDonnell Douglas refused to hire Green because of his involvement in an illegal stall-in outside the plant. To protest perceived racist hiring practices of the company, Green and other employees had stalled their cars and blocked traffic at the time of a morning shift change. Green sued, alleging the real reason he was not rehired was his race. The approach that the Supreme Court provided for sorting out these difficult cases is often referred to as the McDonnell-Douglas analysis or the McDonnell-Douglas test. It also is referred to as the indirect method. The approach is indirect in the sense that it focuses on ruling out non-discriminatory explanations for employment decisions as a way of showing that discrimination is the most likely explanation. The elements of a claim in a pretext case begin with a prima facie case. This is showing by the plaintiff of some basic facts that suggest possible discrimination. If a plaintiff can establish a prima facie case, they do not yet win anything. It simply means that there is sufficient likelihood for discrimination to warrant further inquiry. A court will not concern itself with the employer's reasons for an employment decision unless the plaintiff can first prove that the court has reason to believe that discrimination might have occurred. The main thing that the prima facie case accomplishes is the elimination of some non-discriminatory reasons for denial of an employment opportunity, thereby rendering discrimination a more plausible explanation. In McDonnell Douglas, the plaintiff was able to establish a prima facie case by showing that he had performed well with the company and that he was refused employment even as they continued to seek applicants. Courts are somewhat flexible in how they apply the criteria. For example, lack of stated qualifications will not defeat a claim when the persons hired also lacks those qualifications. A discrimination claim may allege discrimination on the basis of more than a single protected class and some combination of protected classes, but the relevant protected class status must be shown. If a prima facie case is shown, the employer must produce evidence of a lawful, non-discriminatory motive. In other words, the employer should be able to articulate why the plaintiff was denied an employment opportunity. This is not a heavy burden. and the court does not weigh the truthfulness of the employer's claims at this stage of the inquiry. However, the explanation still needs to be reasonably specific and not obviously contrived. If the employer meets its burden of articulating a lawful, non-discriminatory motive, the plaintiff can still attempt to show that the employer's reason is not credible or try to amass additional evidence of the employer's discriminatory motive. An employer's explanation of an employment decision is pretext if it has no basis in fact. As an example, the true reason for not hiring the plaintiff could not be poor interview performance because no interview was conducted, or it has a basis in fact but was not actually a motivating factor. For example, the plaintiff did poorly on his interview, but the decision maker did not bother to get information from the recruiter about the interview before rejecting the plaintiff, or it was a factor, but one insufficient to motivate the decision. For example, the employer regularly hires despite poor interviews. Most often, plaintiffs in discrimination cases lack smoking gun evidence. Their employers usually know better than to verbalize or put in writing statements that express a discriminatory motive. Most evidence of discriminatory motive is circumstantial. Circumstantial evidence hints at the possibility of discrimination, but by itself is not sufficient to compel that conclusion. The McDonnell-Douglas framework is a predominant method used by the courts to analyze disparate treatment cases. It's often referred to as the indirect method because it focuses on whether the defendant employer's explanation for an employment decision is believable rather than on evidence that speaks more directly to the motive. When plaintiffs are required to show that a discriminatory motive was the but-for cause for an employment decision, the divisive factor, establishing that other lawful motives had little or no effect on the decision is critical. But while many discrimination cases use the highly structured approach of the indirect method and center on evidence of pretext, this is just one means of getting the ultimate question of whether discrimination has occurred. When there's sufficient evidence of a discriminatory motive, whether that evidence is direct or circumstantial, plaintiffs can prevail under those anti-discrimination laws that permit a mixed motive analysis. Within a mixed motives analysis, plaintiffs need only to show that a discriminatory motive played some part of an employment decision, which they can do without proving false any lawful motives advanced by the employer. Thus, a more direct approach is also sometimes used by plaintiffs in court. The direct method of analyzing disparate treatment cases is less structured and more likely to be applied in cases where strong, although usually still circumstantial, evidence exists regarding the decision maker's motives. It is important not to confuse this distinction between direct and indirect methods of analysis with earlier mentioned distinctions between direct and circumstantial evidence. The key to the direct method of proof is that the evidence, whether direct or circumstantial, points directly to a discriminatory reason for the employer's action. What if there's evidence of a discriminatory motive by the supervisor, but not by the human resource manager or higher level official who actually makes the employment decision? Insofar as intent is a necessary element of a disparate treatment claim, is the requisite discriminatory motivation present in such cases? This is an important issue because it's common for employment decisions, particularly terminations, to be made or at least approved by higher level managers not well acquainted with the employee in question. Under the subordinate bias, cat's paw theory, the discriminatory motive of a lower level employee can result in liability even though decision-making authority resides elsewhere. Supervisors should carefully select and train supervisors, closely review disciplinary actions, and refrain from excessive reliance on recommendations by lower level managers who might harbor discriminatory motive. The precise boundaries of the subordinate bias theory of liability are not yet clear. In disparate impact cases, the plaintiff does not argue that the basis for an employment decision is something other than what the employer claims. Nor does the plaintiff assert that the decision is based on the plaintiff's status as a member of a protected class. The contention is that some requirement poses an unnecessary obstacle to employment opportunity and harms some protected class group more than others. The discriminatory effects of the employer's requirements and policies, rather than the employer's intent, are at the core of a disparate impact claim. In an important early case, the U.S. Supreme Court was called on to decide whether an employer's requirements for initial hiring and transfers were discriminatory. Prior to the passage of the Civil Rights Act of 1964, the employer, Duke Power, had openly discriminated against African Americans. They were hired, but only for low-paying, strenuous positions within the company's labor department. Immediately after Title VII went into effect, Duke Power instituted a high school diploma requirement for transfers from the labor department to other jobs within the company. Obtaining a passing score on 2 standardized aptitude tests with the cutoff for passing geared at the median score for high school graduates were added as another requirement and later offered as a substitute for the high school diploma. Although employers routinely establish educational and testing requirements for positions, the practical effect of these requirements was to lock into place the prior segregation of African Americans into the worst jobs at Duke Power. This is because in the 1960s in North Carolina, whites were nearly 3 times as likely as African Americans to have obtained a high school diploma, so the requirement disproportionately limited the employment opportunities of blacks. Setting the cutoff score at the median level for high school graduates was an empty gesture, in that the tests were actually a more stringent requirement than a high school diploma. The Supreme Court was thus presented with a case in which the employer's selection criteria disadvantaged African Americans, but there was no evidence that the requirements were instituted for the purpose of discriminating based on race. Citing the broad purpose of Title VII to promote equal employment opportunity, the court ruled that discrimination in the form of disparate impact was just like disparate treatment, which violates the law. Critical to the court's decision was that Duke Power had not sought to determine that a high school diploma or passing score on the aptitude test was meaningfully related to the ability to perform jobs at the company. White employees without high school diplomas who were hired before the high school diploma requirement was put into effect and allowed to stay on the job performed satisfactorily and attained promotions. If an employment practice which operates to exclude a particular protected class cannot be shown to be related to job performance, the practice is prohibited. For several decades that followed, the precedent established by the Supreme Court's decision in this landmark case, Griggs versus Duke Power, was the legal basis for disparate impact claims. In 1991, Title VII of the Civil Rights Act was amended to specifically cover disparate impact claims. Because the plaintiff in a disparate impact case is claiming that some neutral requirement or practice has discriminatory effects, a specific requirement or practice must generally be cited as the culprit. An exception occurs when the plaintiff is unable to do so because multiple factors are involved in making the employment decision, such as hiring processes with numerous tests and interviews, and the scoring and weight of each factor are unclear. Neutral requirement or practice refers to anything other than protected class characteristics used as grounds for making employment decisions. To produce disparate impact, a requirement or practice has to fall more heavily on some protected class group than others. Examples of neutral requirements or practices that have sometimes been shown to have disparate impact include the following: written employment tests, height and weight requirements, language requirements, physical strengths tests, and limitation of employment based on arrests. The plaintiff has to present the court with evidence that any differences in outcomes across protected class groups are large and consistent enough that they would highly be unlikely to have occurred by simply chance. If the plaintiff fails to establish a prima facie case of disparate impact, the employer is not required to defend the challenge requirement or practice. On the other hand, if a prima facie case is established, the employer bears a relatively heavy burden in showing that the challenged requirement or practice is job-related and consistent with business necessity. When an employment test is involved, the employer usually must produce statistical evidence that the test is a good measure of ability to do a job. A requirement, like a strength, might be related to the ability to perform a job, but the specific amount of the strength required or the particular means used to assess the strength still might not be consistent with business necessity. Age-based disparate impact claims brought under the ADEA are handled differently than cases brought under other laws. The employer has the burden of showing that a challenged requirement or practice is a reasonable factor other than age. Considerations relevant to determining whether a factor other than age is reasonable include the extent to which the factor is applied fairly and accurately and the extent of the discriminatory impact and whether other options were considered. Employers need to be prepared to defend requirements or practices whose use results in disproportionate outcomes across protected class groups. Employers should not adopt employment practices without first meaningfully examining their potential discriminatory effects and the evidence supporting their job relatedness. If an employer shows that a challenged practice is job related and consistent with business necessity, then even though the practice produces unequal outcomes for different protected class groups, it's still legal. Disparate impact might be found if the plaintiff can show there is a feasible alternative practice that would produce more equal outcomes, but which the employer declines to use. In retaliation cases, an employee is disadvantaged because of having engaged in a protected activity related to civil rights in employment. If civil rights laws are to be more than a hollow pretense, protecting persons who act to uphold their rights or to help others do so is absolutely essential. As with other types of discrimination cases, courts use a structured approach to decide retaliation cases. This method is similar to how disparate treatment pretext cases are analyzed, but here the focus is on mistreatment stemming from an employee's protected activity rather than because of an employee's protected class characteristics. To have a retaliation claim, an employee must first have engaged in protected activity. Participation refers to involvement in the enforcement of an anti-discrimination law, such as by filing a charge, bringing a lawsuit, giving testimony, or assisting in the investigation of a discrimination charge. Opposition refers to resisting or speaking out against discrimination apart from participating in formal enforcement procedures. Opposition might look like complaining about discrimination to supervisors or contacting civil rights organizations. In general, protection against retaliation does not hinge on the correctness of an employee's perceptions of discrimination. However, protection of employees who engage in opposition is more equivocal than protection of employees who participate in formal enforcement process. Employees who oppose their employer's discriminatory practices cannot engage in illegal activities, disrupt the use of work of others, disparage the company's products, or release confidential documents and still be protected from retaliation. To establish a prima facie case of retaliation, the plaintiff must also show that the materially adverse action was taken. Note that this term does not specifically refer to employment opportunity. The final element of a prima facie case of retaliation is evidence of a causal link between engagement in a protected activity and the occurrence of a materially adverse action. A causal link is usually demonstrated by showing that the employer knew about the employee's protected activity and the materially adverse action closely coincided with the employee's protected activity. These elements of a prima facie case reflect the expectation that retaliation will normally be enacted through an employer punishing the same person who spoke out about discrimination. But what if a materially adverse action is taken against someone closely associated with that person instead? If a prima facie case of retaliation is established, the case is analyzed like a pretext case. The employer must articulate a non-retaliatory reason for the decision they made.